Hi, I'm Lana Shearer with Shearer Law and Mediation in Elk Grove, California, practicing family law mediation. And I'm here with Christine Faulkner, estate planner in Elk Grove, California as well. And welcome to our next session of Family Matters.
Thanks, Lana. So yeah, I'm Christine Faulkner with Cava&Faulkner, and I practice estate planning and generational wealth transfer, succession planning for businesses. So get us started, Lana. What are we talking about today?
So today we're going to talk about the unfit parent. So what the family court criteria uses, what the family court uses as its criteria to determine who would be an unfit parent, and how to make custody orders. And then also, Christine, I wanted to talk about your conversations with your clients and what concerns they might bring up if they are doing guardianship documents, and perhaps wanting to put some language in there about why they might not want the other parent to have guardianship should they pass.
Yeah, so when I'm working with clients and we are planning, for guardianship in the event they pass away with minor children, is there something, so I hear all sorts of crazy stories. Most of them are great, but sometimes they're not so great. And parents really do have significant concerns about their children ending up with the other biological parent. And is there something, is there something that I can be suggesting to my clients that would really boost their case if they did become incapacitated and the other biological parent stepped in, or if they passed away, God forbid, and the other parent stepped in and they really felt strongly that they did not want that to happen? Is there something I could recommend for them to do now in real time?
Right. Absolutely. So if you have a client that is bringing up those type of concerns about the other parent, I would ask them first, have you gone into family court with these concerns? Are there any custody orders, or what are the custody orders in your family court action? Because that's going to be important. If your client is making allegations to you about the other parent, but they've never brought that to the court, that will be problematic if they just include it in their estate plan. Because when a court has to evaluate this after they're gone, if there's no other, corroborating information in a court file, it's not likely to be believed. So if you have a client making those type of allegations, I would suggest that they go into family court now and get some court orders in place, because that's really important.
Yeah, that's a great point. And that's not something that I had ever really considered, to really recommend that they go back, or, presumably back if they're divorced, but not necessarily, right? They could have had an amicable divorce, or they could have just, gone to mediation and everything was okay, and something developed later that wasn't actually part of the record previously. And I imagine that many people are kind of reticent to want to step foot in a courtroom again if they don't have to, but it sounds like that might be a really good strategy if they have those kinds of very grave, serious concerns about their kids ending up with the other biological parent.
Oh, absolutely. So even when you proceed with mediation, we do file our documents with the court, so they do become the court orders. So if there's minor children, there will be a custody and parenting plan in there. And so if anything is changed, and if they have shared custody of the children and something has changed where now perhaps just mother or just father has custody at the time that you're seeing them, but their court orders haven't been updated, like sometimes this just happens between the two of them, I would start inquiring with them, what are your current court orders on custody and visitation? Not just what you're doing between the two of you.
Right.
Because if it's not in court, there's no information in the court file, it's not likely to be believed or carry the same weight as opposed to if they go in and get those custody orders now.
And so what happens if, something maybe happens after divorce, or if they weren't married, but the other biological parent is still around, what does a court look at when they're looking for, I don't know if this is the right language, unfit parent, being unfit parenting. What if somebody is later like a felon? What kind of things does the court look at to determine fitness for parenting, and when, what kind of documentation is needed, and what are the criteria?
So if they have a parenting plan, they were divorced, they have a parenting plan, and things change, and they want to make a change, something has come up, someone has committed a crime, or something has happened either with regarding the children or in some other arena, and the parent wants to change those custody orders because there's a problem, you would file a request for orders to modify the parenting plan with the court, and then the court would have you go to mediation to talk about either what has happened, investigate. It's an investigation in a way. And then that mediator would either help the parties come to a new parenting arrangement, and then that would become the new court orders. You have a court hearing, the judge, here's the parties. If you agree that this is going to be the new parenting plan, then you make orders, and those are the current court orders. If the parties don't agree, and in some counties, the mediator will then make recommendations to the court as to what the mediator feels is in the best interest of these children, based on all the information they gathered from their, interviews with the children, interviews with the parents, and perhaps doing some collateral, checking. And then they would make recommendations to the court. You go to your court hearing, and there's argument, and the court will make some court orders. With regard to the matter of whether or not someone is a felon, that may or may not affect whether or not they can be a fit parent, especially if that felony was committed before this child was conceived. So it's hard to necessarily say someone is an unfit parent because they have a criminal convictions in their background if thereafter you chose to procreate with them and create a child. So, the proximity to when you're seeking custody orders, what type of felonies they are. So just a felony in and of itself is not going to make someone an unfit parent necessarily.
And so if you have a felony involving, it's, I don't know the differences. It's taken me too far back in law school, but I do know the difference between, a crime against your person, right, versus a crime of moral turpitude, which usually involves, theft, lying, dishonesty. Is there a distinction between those types of crimes that a judge would look at per se, or not?
Not necessarily. We're going to look at what is the relationship with this parent and the children. How, are the children developmentally, physically, mentally, how are they healthy? Are they thriving? What is the parenting plan? How much contact do they have with this parent? And then, does this particular crime impact their ability to care for the children, to provide a loving, stable home? Right? It could be, and that's whether or not there's any crimes committed. But the court is still going to look at the same factors, not necessarily, that crime. Obviously, if the crime involved, something with children, some bad act towards children, or particularly with these children, that would be considered. But it's all under the realm of what is in the best interest of these children, to ensure that they have, a bond and frequent and consistent contact with this parent, if being with that parent is, healthy for them, if that parent is able to provide an environment where they can thrive. But a criminal conviction in and of itself is not going to, or what type of crime it is, not necessarily make someone an unfit parent.
So it sounds to me like one of the things that might be useful for my clients is if they do have either ongoing or current custody orders that outline in some detail why the other parent, what those actions may be impacting the other parenting rights. that should be part of their estate planning binder, that we might want to include, those documents at least in the binder contemporaneously, because it seems to me that if people are willing to go back to court to modify, they're getting a contemporaneous history that's documented in the court record about what's going on. And then of course the judge is going to make their decision, but that could influence something that happens later in the probate court if they were to pass away. And it might be good to have all of those records in one place.
It would be. I mean, you can request copies of the files as well. And that's something, that is routinely done because you need to know what those current court orders. So if you had the most current court orders stayed in the estate planning binder, then you don't have to, request a copy of the file because that's a time delay. So that would be a good idea.
And the personal representative or the trustee of the trust, they may not be aware of those court orders, right? They may not be aware that they actually exist. So having them in the binder might be a really good idea. So you've given me some great talking points to discuss with my clients about maybe what they should be doing more proactively if they have these very real concerns, but also just in terms of keeping the documentation in one place. Clearly, having copies of records is hugely important, and it can save time and money and a lot of heartache if you have them in a centralized location. So from the estate planning perspective, that's a really good tip. I'm curious, is there anything in, can you maybe tell a story or when a judge does decide that somebody's either an unfit parent or maybe their rights should be terminated or limited? What maybe a case where you've seen that happen and give us a little bit of information about the facts.
So, there is a process where you can petition to have a parent's rights terminated. It's an uphill battle because the court is going to favor a biological connection with a parent unless that parent truly poses a risk to the child that surpasses that importance of having that biological connection and bond. So I actually have not had any termination of rights, but I have had cases where there was some pretty egregious conduct on the part of the other parent. And even in those cases, the court favors some contact with that other parent, with the offending parent, whether that parent has been abusive to the children or possibly abusive to, the other spouse in the presence of the children, egregious conduct. So some contact is still considered in the child's best interest, but that contact is very regulated. So supervised visitation is a typical provision that would be put in those type of cases. And you can have agency supervised visitation where a professional is paid, and trained in observing these type of situations. It's to stay safe and to take information. They do reports on the supervised visits, and they put that, they submit those reports to the court. So the court will consider those to see how the supervised visitation is going. Or you can have a family member do supervised visitation as well if, the court and the parties felt that was, safe, if those were enough parameters to ensure the safety of the child, because that's what's paramount, is always, the safety and well-being of the child. So while I've not handled any termination of parental rights, I know that it can be done, but I also know that it is an uphill battle.
Yeah.
But definitely I want to impress upon everyone that if you have custody orders, those custody orders should always be current. So if something changes, your schedule completely changes or something happens, you don't necessarily have to file a request for orders and go to a judge and have that stressful hearing. You can do it by stipulation. If you've agreed to this change, you can craft a stipulation in order outlining your new plan, submit it to the court, it'll be signed, and that becomes the updated order. It's really important to have updated orders because you need a record of what your custody plan is. And instead of the informal process of just agreeing between the two of you, you know what's going on, but there's no actual custody orders. And those are important. Having an official record is really important.
Cool. Well, yeah, thank you so much. This has really been hugely beneficial to me because I really feel like I can bring more value to my clients who are in this situation by giving them education and helping them make sure that their binder is even more robust, with all of the necessary documents in the event something tragedy occurred and they passed away, that everything is in the right place to make things easy, because certainly that's one of the things that we do in estate planning is try to make things as easy as possible if somebody becomes incapacitated or passes away, and people don't have to search the four corners to find the information that they need.
Right. Absolutely. Yeah. Having record of what their custody orders are is one important document to have in there as well.
Yeah. Well, thank you for talking about, how you look at the unfit parent or terminating parental rights. I think that, for my audience, for sure, that will be really educational. So thank you, Lana.
Yeah, thank you. You're welcome.
And we'll see y'all next time.
Bye.
Bye.